Yes, Mr. Chair.
My Lords, I'm going to deal with the judge's conclusions on rationality first, if I may.
Yes.
And if I could pick that up in the judgment from paragraph 260, which is on page 141 of the core bundle. At paragraph 262, the judge gives herself two self-directions. The first one is undoubtedly correct. The proper test is not proportionality. That's the proper test in a human rights claim. But on ground 5, I propose, she says, to apply the rationality test with anxious scrutiny, as I found that human rights were engaged. We say that was a straightforward error of law. And that's because, as the judge herself found, the human rights of the taxi drivers were not, in fact, engaged, because the level of interference imposed by the plan, the guidance, and the A10 order was not such as to amount to an interference with their possessions. And so in those circumstances, anxious scrutiny was not the right test. The authority we rely on for that proposition is the decision of the Court of Appeal in Poirot, which is Authorities Bundle at tab 21. This is the latest episode in the Chagos Islanders litigation. The relevant passage is paragraph 152 in the judgment of the court.
Which paragraph?
152, my lord. And picking it up at letter F, the Court of Appeal say, we agree with the Divisional Court that this was not a decision that should be subjected to anxious scrutiny, and that's because there was no interference with human rights. And that was because, as in this case, it was found that there was no interference with possessions under Article 1 of the First Protocol. So anxious scrutiny was not the correct test. And we say that error in self-direction was material. It's apparent from the judgment that the standard of review adopted by the judge was quite far removed from traditional notions of Wednesbury irrationality. Even if the court concludes that that submission is incorrect, we say that the judge's approach to rationality as applied to an emergency pandemic measure was also wrong. The judge didn't have the advantage that this court has of the decision of this court in Dolan, which is at tab 20 of the Authorities Bundle. Dolan was a rather more wide-ranging challenge to various pandemic measures, including measures, of course, that are much more intrusive than those that are in issue before the court today. I won't go through the measures that were challenged, but they're set out between paragraphs 15 and 22 of the Court of Appeal's judgment, and they contain all the rules that we've become all too familiar with over the last year: closure of businesses, places of worship, prohibition on leaving home except with a reasonable excuse, prohibition on gatherings, and so on. The approach of the Court of Appeal to a rationality challenge was dealt with in the judgment between paragraphs 87 and 90. And the conclusion of the court at paragraph 90 is that we find it impossible to accept that a court could possibly intervene in this context by way of judicial review on the ground of irrationality. Powerfully expressed conflicting views about how many of the measures taken by government and how various balances should be struck. That's quintessentially a matter for the political judgment for the government, accountable to Parliament, not suited for determination by the courts. So comparing that, if I may, to the judge's approach, if we could go back to the judgment, picking it up at paragraph 266. The judge's first conclusion at 266 is that the flaws, which she'd already identified, were symptomatic of an ill-considered response, taking advantage of the pandemic to push through, on an emergency basis, without consultation, radical changes planned to transform parts of central London, and so on. Then paragraph 267, the judge concludes that the evidence is strongly suggestive that the schemes would become permanent, but there's no evidence to suggest there'll be a permanent pandemic requiring continuation of the extreme measures introduced by the government in 2020. Now, even if the judge was correct that TfL might be considering in the future making some of the arrangements permanent, that doesn't make the schemes irrational. The question is whether there was a proper and rational basis for the schemes in response to the pandemic. Whether in the future a permanent order, for example, should be made in relation to the A10, which would have to be following a statutory process of consultation, and necessarily the order would have to be for very different reasons, is a different issue for the future. But the suggestion...
Mr. Chaffey, could I just pick out a little? Clearly, if there was a predetermined scheme that had no basis, and there was an adventitious motive for bringing in temporary measures that might then become permanent, that might undermine the justification for the temporary measures. That's rather a different question, isn't it, from the fact that, well, it's justified by what we face now, but we anticipate some of it may become permanent. Isn't that the...
And so one example with that would be the suggestion in the guidance that you should bring forward in-flight schemes. So, for example, if you're already intending to build a cycle lane between A and B, why not do it now and hurry up? And you're always intending to do it. You consulted on it previously. It was something you had in progress, and after the pandemic you might keep it, having already built it. But that doesn't undermine the fact that you are doing it at that time under a temporary order, often using temporary materials which are not designed to survive for the long term, for the purpose of the pandemic.
So the submission is?
Well, to the extent there is some suggestion here that there is some ulterior purpose, or that the order and the guidance can be criticised on the basis that some of these schemes may ultimately be consulted on and become permanent, is wrong. Take the A10 order, it automatically expires by operation of law once social distancing.
Well, that's obviously so of the A10 order, but if one focuses first on the macro claim rather than the micro claim, the question is whether the interim guidance is truly interim. The judge, I asked Mr. Mathias about this afternoon, but paragraph 266 seems to be almost to be a finding of bad faith on the part of everyone who's given witness statements on behalf of the defendants, that they're seeking to conceal the fact that they were taking advantage of the pandemic to push through permanent changes.
And I respectfully suggest that there was no basis. If that is indeed what the judge was suggesting, there's no basis in the evidence for that. Otherwise, it's difficult to understand the text of the press releases and the guidance themselves, which at every stage are explaining how this is a response to the urgent requirements of the pandemic rather than anything else.
Is there in fact an allegation of bad faith or anything approaching it in the claim?
I don't believe that allegation was made. Then at 267, as we've seen, the judge says there's no evidence there'll be a permanent pandemic. Well, indeed, we all very much hope that's the case. And that's why the relevance of this guidance, and indeed the A10 order, will come to an end with the pandemic. If one just imagines the situation of TfL trying to do something post-pandemic in reliance on the guidance, such a decision would be obviously unlawful. The court would have, TfL wouldn't do it, but a court would have no difficulty whatsoever in quashing that. The guidance would be completely inapplicable. Then the judge turns at paragraph 269 to analysing, we say, the merits of the restrictions on motor vehicle access. So the judge says that the stated justifications that after lockdown there'd be limited public transport capacity and a major increase in pedestrians and cyclists and consequent risk to safety. Now, the judge then castigates this as being mere conjecture and not a rational basis on which to transform London's roads. Well, it was the professional judgment of TfL that that was the risk which they faced, and TfL, of course, do have some expertise in transport planning. It also turns out that TfL's concerns were correct. I mean, I can't place too much reliance on the fact that the proof of the pudding is in the eating, but as to the question of whether TfL's concerns were so outlandish as to be irrational, I submit that they were not. And then 269 continues with the judge saying, well, it must have been apparent to the Mayor and TfL that people were responding to the pandemic by staying at home, especially office workers. And so it was possible is doing quite a lot of work there, that they would continue to do after lockdown to avoid infection. Do so after lockdown to avoid infection. Central London was deserted during lockdown. Even once the lockdown was relaxed and the government exhorted people to return to work, people chose to remain at home where possible. It is quite important not to confuse the experience of, for example, me as a lawyer of lockdown with what is in fact happening on London's roads. Of course, central London was deserted during lockdown, but after lockdown was relaxed, as TfL predicted, traffic levels on the roads quickly returned to levels close to normal. The office workers didn't rush back to the offices, but it's the road network that's of interest to TfL. The judge then says at 270 that traffic levels in the city remained well below pre-COVID levels. The judge doesn't cite any evidence for that. And indeed, earlier in the judgment, we looked at, in the course of my submissions this morning, that was not the evidence that was before the court. The evidence that was before the court is that after the first lockdown, as TfL predicted, traffic levels recovered quickly. They're not quite at normal levels of pre-pandemic London, but normal levels of traffic in pre-pandemic London involved very high levels of congestion and delay, which is what TfL was trying to avoid.
What's the source of the statement of 270 for traffic levels have remained well below pre-COVID levels?
Well, with respect to the judge, I'm afraid I don't know. The only evidence which is cited about those levels is the evidence which we looked at this morning at paragraph 31 of the judgment, on page 78 of the core bundle. And these are the figures as at October. Roman 3, traffic counts in central London, so that's all central London roads, were 79% of normal demand. That's 3A. But 3, on the main strategic routes through Greater London, it was 91% of normal demand.
Sorry, I missed the reference. I do apologise.
Sorry, it's paragraph 31 of the judgment.
Oh, I see. You're back to the judgment.
Yes.
That's October 2020.
Yeah.
And for what it's worth, at paragraph 29, the judge also records the evidence about taxi usage in London.
The facts and figures in 29, 30 and 31 are not contentious, is that right?
I don't believe so.
So in answer to my Lord's question, you're surmising, because I think you said you weren't sure, but you're surmising that she's relying, the judge is relying at 270 on what is set out in those 3 paragraphs earlier.
Yes, and I submit that they don't support that conclusion because traffic levels quickly recovered.
In any event, is it logically right to look at what happened when assessing a prediction?
Well, no, but all I can say is that that was TfL's reasonable prediction, and the question ultimately for the court is whether that prediction is a rational one that a properly directed public transport authority could have reached. And the fact that that is what happened in reality, I'd say, is a relevant factor. Just show. But of course, TfL might have got it completely wrong. But nonetheless, if it was a proper and sensible prediction on the evidence they had before them, then it's a rational decision. But I don't need to go as far to make that submission. It's just that TfL thought it would happen, and it did happen. Then at 271, the judge deals with the specific evidence which was pre-pandemic relating to Bishopsgate. And pre-pandemic, the evidence was that 40% of vehicles other than buses along Bishopsgate at peak hours in the morning were taxis. And the claimants challenged the reliability of that figure, contrasting it with lower figures based on number plate reading data. And that was that taxis comprised 17.8% of all vehicles in the congestion charge zone from the 2nd to the 6th of March 2020, and only 5% of vehicles across Greater London during the same period. Well, it's very interesting that, for example, TfL's own figures are that 43% of non-buses on Bishopsgate are taxis, and that figure is lower for the whole of the congestion charge zone. And that's because taxis are a particularly important part of the traffic mix going down Bishopsgate. It's a very popular traffic route. It's not obvious why that helps the claimants, though. That just shows why tackling the prevalence of taxis on that route may be essential in order to meet the aims of the scheme.
Is the 43% figure really from 1999? Was that it?
No, it's 2019.
2019.
2019. Yes, I think that's a typo.
So, yeah.
And then at the end of 271, the judge says, remarkably, TfL continued to justify the A10 order by reference to the 43% figure without taking into account the drop of traffic caused by COVID-19. Well, we say that's quite difficult to understand because that's about what the mix of traffic was on Bishopsgate, not the absolute number of vehicles. The 43% figure was useful and valuable to TfL because it said that on Bishopsgate, prior to the pandemic, taxis were a very important part of the traffic mix, that once you take out buses, they were the single largest category of vehicles. And there was no reason to think that would change post-pandemic during the recovery. And so therefore, TfL reached the view that they needed to do something about taxis as well as about other vehicles if they were going to achieve the aims of their scheme. And that's, of course, before one takes into account TfL's concerns about taxis using the route preferentially if they were allowed in. Now, the possibility of taxis using the route preferentially is dealt with by the judge at 272. And the judge says in the fourth line of 272, there was no evidence produced in support of this proposition. And whether or not it was correct would obviously depend on the number of taxis wishing to travel in that direction at any one time. Well, that is, with respect to the judge, not true. That evidence was the result of the modelling which TfL carried out, and it's cited in the judge's judgment at paragraph 59 that that was the results of the modelling, and that was the evidence before the court. And this is a point at which the arguments intersect with the judge's approach to admissibility, that Mr. Monk, the TfL witness, commented in his statement as to whether that modelling was likely to be correct in his professional opinion, and he explained that it probably was correct in his opinion and gave reasons for that. The judge excluded that evidence. So TfL was not permitted tell the court that the modelling which it relied on was correct and the reasons why it thought it was correct.
And you complain, and then the court says there's no evidence.
Yes. So one of the reasons there's no evidence is because there was evidence, and it was cited by the judge at 59, the modelling evidence. But as to the correctness of the model, the judge excluded that. But more generally, we say that this entire analysis shows a misunderstanding of the purpose of the A10 order, because the A10 order was designed for the recovery phase. So when social distancing was still required, but traffic levels were recovering when people were out and about again. It's not about the period during a lockdown when you're required to stay in your home, but it's about how, with a virus still circulating, with social distancing still required, you can get some semblance of normal life back. What the judge is doing here is a form of merits review, is, we say, particularly clear from 273. The judge says, if the Mayor and TfL had proceeded more cautiously, monitoring the situation and acting on evidence rather than conjecture, their proposals would have been proportionate to the difficulties which needed to be addressed. I mean, for what it's worth, the judge has applied the wrong test there. This is not a proportionality case, this is a rationality challenge. Leaving that aside, this is a clear substitution of the judge's analysis of the merits for that of TfL. And that's clear from the rest of the passage. The A10 order far exceeded what was reasonably required to meet the temporary challenges created by the pandemic. And the judge's conclusion is it was possible to widen pavements to allow for social distancing and allocate more road space to cater for an increase in the number of cyclists without seeking to transform parts of London into predominantly car-free zones. Well, it is quite difficult to achieve all of those things at once. To say that you can widen the pavements and give more road space to cyclists without making the road narrower and therefore making it necessary to potentially exclude certain classes of vehicles. If you want to create, for example, a safe cycle route to encourage people onto bikes and feel safe and comfortable on their bikes, and you want to keep the buses on that route, then you're going to need to reduce other traffic. And we're there in the position of priorities and trade-offs in an emergency. And it would be nice to live in a world in which such trade-offs did not exist, but they do. So the judge's conclusion is at 274, it was unfair and irrational to introduce such extreme measures if it was not necessary to do so when they impacted so adversely on certain sections of the public, which the judge then identifies. And the judge correctly identifies that the impacts are likely to be on the elderly and disabled who rely on a door-to-door service, in particular on those two sections of Bishopsgate. The difficulty with this as a rationality challenge is that TfL was well aware of that disadvantage, but chose in the exercise of its judgment, because it believed that significant risks to human life and human health were at risk, and thought it could do more for the public good by introducing the scheme. So that's rationality, my lords. Dealing then with the judge's analysis on failure to take account of relevant considerations, could I ask the court to go back in the judgment to paragraph 145?
Ground 1.
Yes, this is ground 1. And I'll deal first with the plan, so that's the press releases. So at 145, the judge summarises the position in relation to the plan. And then in the second half of 145 deals with the press release of the 15th of May. And then the conclusions of the judge start to be set out from 146 onwards. I should just add, before we leave 145, the judge says in the last sentence of 145, the plan did not mention taxis. The press release of the 15th of May did refer to taxis. It referred to accessibility, and it explained that at that point, what was being tentatively proposed was that the zero emission capable taxis would be allowed into these areas. So that's just incorrect as a matter of fact. But then 146, we start to get to the conclusions. The plan did not recognise the long-established status and role of taxis as a form of public transport, distinct from other cars, reflected in law, policies and mayoral statements. Then the judge cites the bus lane policy and says the proposals were inconsistent with TfL's bus lane policy, which is then cited. And then on paragraph 2, the judge says, in my view, the proposal for bus cycle corridors plainly went far beyond the limited exception in paragraph 2, that's of the guidance, which has been applied for specific space safety reasons in a small number of locations on a case-by-case basis. Then the judge's conclusions at the end of 146 are that the plan, that's the two press releases, did not even acknowledge the bus lanes policy, let alone apply it, nor did it give reasons for departing from it. So really there are three criticisms: that TfL failed to acknowledge the bus lane policy in the press releases, secondly that it failed to apply it, and thirdly that it failed to give reasons for departing from it. So failure to acknowledge the bus lane policy. Well, we say the answer to that is that when formulating a press release containing a general statement of policy, TfL was certainly not obliged to refer to and list every existing policy which remained in force, which may be relevant to the taking of substantive decisions under that general statement of principle. That would have made a press release quite unmanageable. What they did do is they did say that any actual schemes would be subject to liaison with the boroughs and traffic management orders, so a further decision-making process. And public authorities are free to adopt multiple freestanding and interrelated policies. And it's when those policies are applied in a specific case that they have to be reconciled and read together. We would say that was the ordinary approach. And of course, policies don't always pull in the same direction. You may have an environmental policy and a development policy that may indicate different conclusions or different types of conclusions. And reconciling those and applying them and deciding what's more important is the art of public authority decision-making. But you don't render guidance, at most, or a general statement of principle in a press release unlawful, or failure to refer to one other statement of policy that's relevant when substantive decisions come to be made. I mean, taking it at its most extreme, if that argument is right, then the mayor's transport strategy is also unlawful, because it proposes the introduction of bus and cycle only corridors and doesn't expressly cite the bus lane policy. The judge then says, well, there was a failure to apply the bus lane policy, but at the stage of these press releases, there was nothing to apply the bus lane policy to. The express terms of the guidance says it has to be applied case by case to specific circumstances. And so it couldn't be applied at that point. And of course, we say that's what happened. And thirdly, the judge says, well, no reasons were given for departing from the bus lane policy. We say there was no departure from the bus lane policy because the terms of the policy itself allow for restrictions on taxi access for safety and operational reasons. Then 147, the plan is criticised for not referring to the importance of taxis for people who are elderly or disabled or with heavy luggage. Well, the 15th of May release did refer to accessibility, and there was a detailed analysis of accessibility issues in the accompanying guidance. And this morning we looked at the equality assessment, which was conducted in relation to the guidance. Just for my Lord's note, it's page 430 of the core bundle, which expressly deals with these issues. We do respectfully say the judge is asking a bit too much for all of these issues to be dealt with in this way, in what is ultimately a press release and some interim outline guidance. And that leads at paragraph 148 to an inference which the judge draws that the Mayor and TfL did not take these matters into account. The status and role of taxis was of such importance to the viability of the proposals and their impact on taxi drivers that if they had been taken into account, they would have been mentioned. Well, we say that's just a plain mistake, because on any view, the 15th of May press release does refer to the position of taxis and what access should be allowed for taxis. So clearly it was on TfL and the Mayor's radar at that point, and it was a point they were considering and they had proposals for. The judge then adopts the same analysis at paragraphs 149 to 152, having looked at the plan in relation to the accompanying guidance. And the answer of TfL is essentially the same. You can't apply the bus lane policy at the point of publishing general guidance, and that's because the policy itself says it should be applied on a case-by-case basis. You also couldn't, in the guidance, tell the boroughs to apply the bus lane policy because quite a lot of the boroughs don't agree with it. It's not their policy.
And is this right that TfL can tell them what to do for the strategic roads, but can't tell them what to do for any other roads?
Yes, I mean, in fact, it goes slightly further, which is that the TfL roads belong to TfL, and TfL decides what to do in relation to them, and manages them itself. In relation to other roads, there is a duty on the boroughs to notify TfL of its proposals, and then TfL has some quite extensive powers to stop things and to call them in, but not necessarily to require boroughs to do things. So TfL's powers to stop things on borough roads are greater than their powers to make things happen. That's a very potted summary of powers, but that's very roughly the way they play out. So we therefore say that the judge's conclusion that in adopting the plan and the guidance there was a failure to take into account relevant matters was incorrect. The judge accepts that all relevant considerations were considered when making the A10 order, and there's no respondent's notice suggesting that finding was wrong. So that's relevancies. The next ground is the public sector equality duty issue.
Yes.
Now, again, I'll split this up into the plan and the guidance, first of all, and then the implementation with the A10 order. The authorities on the public sector equality duty will be very familiar to the court. Can I just identify two of the authorities that are particularly relevant to this case? The first one is the decision of Mr. Justice Ousley in the Fawcett Society case. It's at tab 11 of the authorities bundle. And This decision is useful because it explains how the duty operates differently as between a broad statement of principle or policy and a detailed proposal, particularly when there's a two-stage decision-making process, where first of all, the decision-maker announces a broad principle or policy and then proceeds to implement it with a further decision. So this was a public sector equality duty challenge to the emergency budget of the coalition government in 2010. And one of the issues which arose was whether or not there should have been an equality assessment of individual line items in the budget before the budget was announced. And Mr. Justice Ousley's conclusions start from paragraph 8. Where he says it's clear that if the analysis of the gender equality impacts of the budget can adequately be undertaken by consideration of the line items, the duty is fulfilled, or rather not breached, by its being dealt with in that way at that stage. So, in other words, it's not necessary when announcing your general budget proposals to carry out an equality impact assessment of the individual line items, so long as you're going to do that later. Then paragraph 10, the submission made by counsel for the Chancellor is accepted, that when to deal with the equality impact assessment is a matter of judgment. And then that is applied by the learned judge at paragraph 15. And the third line of paragraph 15, Mr. Justice Ousley says it's perfectly sensible for the government to wait until the policy has been adequately formulated, for there to be a clear basis on which its equality impact can be assessed. The point at which that is reached is, in my judgment, very much a question of rationality, not duty. And that's only a first instance decision. One gets the same flavour from a recent judgment of the Court of Appeal, which I'll just give you the references to, if I may. It's the decision in Gathercole, Authorities 23, paragraph 26, where Lord Justice Coulson conducts quite a lengthy review of all of the public sector equality duty cases and explains how all of those authorities have to be read in a context-dependent way, depending on the exact nature of the decision which is being considered. That is, so far as I'm aware, the most recent statement at the level of this court.
Which paragraph should we look at?
Have a look at, it's tab 23,
yes.
Paragraph 26.
That refers to power and decorum.
Yes.
Yes. This is Lord Justice McComb saying, my judgment in Bracking was not a statute, nor the Ten Commandments.
Yes, although it has sometimes been treated as being an inflexible checklist.
But wasn't Bracking approved somewhere else? Did I not find it somewhere else?
Yes, Bracking has been referred to, for example, at the level up to the Supreme Court, for example, and this is noted by Lord Justice Coulson at paragraph 24 of Gathercole.
That's right, that's what
and he cites that. And then subsequently, judges have noted the fact-sensitive nature of the exercise, that's 25, and then 26, need to be cautious not to read it as a statute, and then gives an example at the end of 26, that the decision of a minister on a matter of national policy will engage very different considerations from that of a local authority considering whether to take a particular step in ongoing proceedings in relation to an individual unit of housing. So that is a statement of principle, which is very similar in our submission to the approach of Mr. Justice Ousley in the Fawcett Society case, who analyses with care the particular context in which a decision is made and the appropriate time for the most detailed form of equality impact assessment may be later rather than earlier. Now, what happened in this case is that, as the court saw this morning, there was an equality assessment which was part of the guidance in the core bundle at page 430, and we went through it. COVID-19 disproportionately affects vulnerable communities. It's explained that the policy is one that was expected to have good overall equality impacts for obvious reasons, but it was made clear that the duty would apply, that an assessment needed to be carried out, and the specific proposals needed to be carefully addressed and analysed at the appropriate time. Now, we say that realistically there's not actually much more that, in the circumstances TfL faced, a public authority could do at the stage of producing general guidance. As best TfL could, it analysed what the likely effects of its broad policy was likely to be, but it said that, well, you're going to have to look at this very much case by case to see what the impacts actually are. Yeah, the judge's conclusions in relation to the guidance can be seen at paragraph 186 of the judgment below. So the judge refers to the submissions which were made by TfL, that they were an assessment of the effects of the guidance to the extent that was possible, and that is concluded as falling far short of the detailed and conscientious scrutiny which was required, and what was done amounted to a mere justification of the decision already taken. The specific needs of the elderly and disabled, which were not capable of being met by public transport or active travel and were met by taxis instead, were known to TfL, and they were not assessed in the context of a policy which described suppressing motorised traffic, including taxis, as a key objective. No investigation or consideration of the adverse impacts that restricting road use by taxis could cause, so TfL didn't pay due regard. We suggest that that approach does not give appropriate meaning to the words due or regard in the duty. The word due is important for the reasons that are explained in those two cases. The extent to which analysis is sensible or useful rather depends on the stage at which a policy has reached. It may only be possible to make a relatively generic analysis of a general policy, reserving issues of detail to when an actual proposal has been worked up. And the concept of regard is important too, because the duty is not a duty of outcome. When producing the plan and the guidance, and this is clearly explained in the guidance, the conclusion of the decision makers was that they gave particular importance and weight to public health concerns in response to a pandemic. Unsurprising that that's the case, tens of thousands of Londoners had died already, and they wanted to prevent further infections as their primary equality consideration. Because, as it points out, the pandemic is not particularly equal. It does affect particular groups more than others. So we say the judge applied an incorrect approach to the public sector equality analysis of the plan and the guidance. That brings me on then to the A10 order itself. The equality assessment of the A10 order is in the bundle. This is the A3 copy that I handed up this morning at page 528 of the supplemental bundle. The judge didn't think much of the document, so it's necessary to have a look at it. So, first of all, on the front page, page 528, there is a summary in the middle of the page of the key residual risks. And it's explained, for the reader with little time, the main risk on this scheme is for people who may require door-to-door travel arrangements and will not be able to access the two areas that will be restricted to pedestrians, buses and cyclists.
I'm so sorry, I'm just not with you there. Where are you?
Page 528, my lord.
Yeah, I'm sorry, I found it now.
Yeah, middle of the page, there's the summary of the assessment.
Yeah.
So clearly set out on the front page of the assessment what the key equality issue is once TfL have designed the scheme. Then over the page at 529, there's a summary of the scheme. I'm not going to go through it, but it makes all of the usual points about greater bus capacity, social distancing, reducing bus journey times, and that it is temporary. The final paragraph in particular, on a temporary basis using temporary materials. Then page 530 is the substance of the assessment. If I can pick it up at impact number 7.
Mr. Jaffe, can I just make sure I've got the right document? I was sent, I think, yesterday, and I got printed out, an enormous document, and I hope it's the same one.
It is,
top left, construction work will be required to implement the scheme. And it's plain, yes.
Yes, so
encouraging nod.
I think Mr. Mathias has a bigger printer in his chambers.
This came as a result of my request, I think, because I was really struggling with
Page 530 is.
It's the same document.
Yes,
it is
the same document. Yes.
Good. Right.
I think we've all got this.
I'm going to use the big one.
Go. I can deal with it.
I'm afraid I haven't been treated to an extra large. Oh, I have.
Oh, Lord, there is one here.
There's,
Oh, well, if there is one. Yes.
I find it a good deal easier to read.
yes. So impact number 7 is where they begin to become relevant to our case. So the proposed change on the left, it sets out the restriction. It's made clear that the restrictions will affect taxis, and it's also explained that there are 2 stretches of road that won't be accessible by vehicles except for buses and cycles. Then the next entry is impact for customers or staff, and it's explained in the last sentence of that box that this may have an impact on people who are unable to walk but require access. Then there are some mitigations and recommendations, and they are to maintain access to the taxi rank, and there are some alternatives for some retail units. And then there's a cross for the word partial, so it's recognised that the mitigation is only partial. And then the explanation is that access to the taxi rank will remain, and then for those accessing the area by foot, cycle or bus, things may become easier. And there's a colour coding of the residual risk, which is orange, which is defined on page 535 as being likely to have a negative effect on the identified groups, unlikely to prevent access or the completion of a journey, greater inconvenience, and it may result in discrimination. Then going down to impact 11, will be an impact on those who require dropping off close to their destination. If they can't be dropped off close, then they may not be able to make the trip. So this assessment recognises that there will be cases of people who may not be able to make a trip. The evidence to substantiate the impact is those two sections of corridor that we've discussed. Then access to the corridor is maintained except for two stretches. And there is a criticism, which is, I think, made by my learned friend and by the judge, that impact number 11 is coded green. And that's because 11 and 12 have to be read together. And one can see there is no line between 11 and 12 under the heading impact for customers and staff. What 11 is considering is the area outside those two stretches. And 12 is considering the possibility of allowing access to those two sections of corridor where buses and cycles are permitted. And
so the coding, the orange coding is correct, is it?
Yes. So in relation to 12, which deals with the particular areas where access is not possible by vehicle except bus, in 12 there is a cross by none for mitigation implementation, because the only thing that you can do is to allow vehicle access, and that they're not proposing to do that. And then there's an explanation as to why. And the explanation is in the final box in 12. Retaining as much access as possible along the corridor has been a key principle. Certain premises and roads may only be accessed from Bishopsgate as a result of other restrictions. The proposed changes have been considered throughout the development to maintain as much accessibility as possible. And then there's further explanation in box 13 in relation to impact 13. And it's noted in the first box for 13, this will potentially impact on taxis to facilitate suitable journeys. Taxi journeys may be longer and more expensive, and so on. And again, what's considered under mitigation recommendations is to permit access through the bus gates for taxis and private hire vehicles. And then there's an explanation of why that's not going to be allowed. And that's the explanation which also appears in the decision-making documents. And it's coded orange or amber. And then finally, box 15. TfL note that the changes will result in new layouts for all road or pavement users. It's noted that they can be confusing for some groups of people. And what TfL intends to do is to have public communications with stakeholders about the changes to ensure that they're well known. So that's the impact assessment, and you've seen that it was further analysed and provided to the decision makers in the decision recommendation document. The judge's comments, or the judge's analysis, we get from paragraph 189 onwards. The first thing the judge said is that these impacts which were identified should have been coded red rather than amber. Well, in relation to that, the true question is whether or not TfL understood and had identified the equality impacts and gave them due regard. And it expressly said in this document that it understood that there would be cases of people who would not be able to make the journey they'd intended, and then considered whether it was going to change the scheme in order to alleviate that. An amber coding does mean that there may be unlawful discrimination, so it is a serious thing that TfL are identifying.
Well, your submission is that TfL did not mislead itself.
No, TfL understood perfectly well what the effects of its scheme were, and for good measure set them out in writing, and put a summary of the biggest problem on the front page.
Yeah, I mean, the submission is actually did not mislead itself in having due, and you emphasise the word due regard to these impacts.
Yes, the purpose of the public sector equality duty is to stop a public authority from failing to consider by inadvertence, perhaps even by design, the consequences of what they're doing. And that's not in our submission what TfL have done here. Then paragraph 190, the judge says impact number 11 should have been read. Paragraph 191, the judge criticises this. Impact number 13 is the one that specifically deals with taxi access. And the criticism the judge makes is that the impact assessment didn't state that the additional cost would elevate the cost of journeys above the level of the subsidy under the taxi card scheme. Well, whether or not the additional cost of a journey around Bishopsgate would exceed the level of the subsidy under the taxi card scheme would depend on some evidence. But certainly that is not an issue in our submission which needs to be expressly dealt with in an equality impact assessment. This impact assessment expressly stated that journeys around Bishopsgate by taxi could take longer and could well be more expensive. And that was a sufficient statement by TfL of their understanding of the position. It's not possible to do a further analysis of the exact extent to which a particular capped subsidy under the taxi card scheme might or might not be exceeded. Then 192 deals with impact number 15, and it's slightly curious. It deals with how new road layouts may be confusing to some people, in particular people with sensory impairments or with mental health difficulties. And you've seen that what TfL intended to do was to engage with community groups about the changes. What the judge says, accepting my learned friend's submission at the end of 192, is that the proposals don't suggest that conscientious consideration was given to the disorientating effect for a blind passenger of being dropped off 100 metres from their destination without any ability to find it, and the residual risk code was orange. Again, it's not completely obvious what TfL was meant to do in these circumstances. It must be possible to make changes to the road layout, including in response to a pandemic, but not only. Inevitably, that will have a disorientating effect for some people, which TfL addresses by the usual mechanisms which it takes. So when we get to 193, which are the judge's conclusions, and the judge puts the criticisms quite high of this impact assessment, we suggest that they become a straightforward disagreement with TfL's view about the merits of this scheme. We suggest that TfL was not irrationally understating the risks. It was well aware of what the risks and difficulties were, but what TfL thought is that what weighed in the other side of the equation were concerns of an altogether different order. And then at 194, there's an even more far-reaching finding, which is that the equality impact assessment was merely a formality and the outcome was a foregone conclusion.
Well, that again comes somewhere close to bad faith, doesn't it?
It does, my lord. It is a very serious finding against the public body.
Presumably the decision, if this is right, the decision could never be retaken because it would be said that it was just an attempt to justify what was done last time.
Well, certainly not by these decision makers.
Yeah. Who is Mr. Powell, and why did he have to approve the scheme on the 1st and 15th of July?
Mr. Powell was the senior TfL officer who ultimately was responsible for approval. as I understand it.
So when did the order come into effect? Whose was the last decision?
The last decision, and just going to the document so you can see the signature.
We've seen the Road Space Performance Group, 11th of June 2020.
That's right. So the decisions in principle were taken at that big meeting, and then the formal documents are the documents at tab 52, which we went through this morning, and they were signed off by 3 people. And this is page 490. First of all, Alexandra Batley, who's the Director of Delivery and Planning. Secondly, Mr. Barton, who's the Director of Network Performance. And thirdly, Mr. Powell, who's the Managing Director of Surface Transport. So the decision is ultimately taken by 3 people at director level within TfL. TfL have their own internal procedures as to what level decisions have to be taken at.
And then the order itself is the 16th of July and comes into force.
That's right. The document at page 490 doesn't have the signatures of those individuals on because they gave their approval in emails. I don't think we've given you all those emails in this bundle. I don't think we need them. But it's not in dispute that it was the order was, or this decision was taken by them. So we do say it is quite a serious finding which has been made by the judge. And we say it's plainly not true when one looks at the decision documents, which set out the disadvantages of the scheme very fairly and invite proper consideration to be given to that. It was all set out for the decision maker. At 194, having made these quite serious findings, it is notable the judge doesn't actually explain which parts of the decision documents read as if they are merely a formality and a foregone conclusion. The final ground on which the judge found against the appellants is ground 4, which is legitimate expectation. There is very substantial overlap between this and the other grounds.
Yes.
And what the judge said is there was a representation to all taxi drivers as a class that taxis would be allowed to drive on bus lanes and enter bus lanes, except where to do so would cause significant delay or worsen safety. So a representation in the form of the bus lane policy was what the judge found. And the judge found that the plan and the guidance failed to consider as a relevant consideration the position of taxis, and so therefore there was a breach of a legitimate expectation as well as a failure to take into account of relevant considerations. I hope it's fair to say that I think this argument probably stands or falls with whether or not the judge correctly analysed the question of relevant considerations. And the mistake which we say the judge made is that there is an assumption that there is some incompatibility between the press release and the guidance and the bus lane policy. And we say they all comfortably sit and sensibly sit side by side. Again, some of the findings which the judge makes, we respectfully suggest put the position quite high. So just by way of example, at paragraph 247, in the first half of 247, the judge sets out or summarises the terms of the scheme. And then at the top of the next page, there's no evidence that TfL ever considered the significance of the bus lane policy and policy guidance when deliberating over the terms of the scheme, including access to taxis. Instead, it considered it had an untrammelled discretion to exclude taxis, which was erroneous both in fact and law. If TfL truly thought it had an untrammelled discretion, it's far from obvious why in its decision-making documents it considered those issues, we say, in proper detail. There's no suggestion that TfL thought that, in fact, its discretion to exclude taxis was untrammelled. To the contrary, it commissioned, for example, specific modelling and analysis on the effect of its proposals on taxis. And then 248, the judge seems to be under what we say is a misapprehension that TfL was seeking to depart from the bus lane policy. We say that, of course, the TfL was not departing from the bus lane policy, it was applying it properly. And then from 249 onwards, the judge deals with the question of whether the legitimate expectation should be upheld in the circumstances of a pandemic. My submission was that whether to uphold an expectation in those circumstances was very much in the area of macro and political decisions that permitted departure from an expectation. That's a submission which we would say is supported by the Court of Appeal's judgment in Dolan. The judge then rejected that submission at 251. The submission was severely undermined by the fact that, unlike many of the authorities, this is not a case where the decision maker has amended or revoked the policy. The bus lane policy and guidance are still operative, and the Mayor and TfL has not suggested they intended to revoke them. Yeah, we say that's a strange finding because the letter which TfL wrote to the taxi drivers when it took its decision was drafted using the language of the bus lane policy. It was an application of the policy.
Just give us that page reference again. We did see it.
Yes, the page reference to that letter, and it's yes, it is.
Dear Steve letter.
Yes, it's Dear Steve. Reply. There it is. It's tab 59 of the supplemental bundle, page 538. And then finally, and I think briefly, there is the evidence which is excluded by the judge. There's not much quarrel by the appellants with the approach the judge took on the law, and the judge's judgment on this issue is at tab 8 of the core bundle. Everyone agrees that the evidence in a claim for judicial review is meant to explain the decision-making process. It's not an opportunity for ex post facto rationalisation of the decision, but it is common ground, I understand, between the parties that elucidatory evidence, so for example, evidence which explains facts and matters that are well understood to a professional decision maker, but which may not be apparent to a judge who doesn't work in that area, is perfectly proper. Helpfully, the judge prepared a track changes version of Mr. Monk's witness statements, so it's very easy to see what's been excluded.
Yes.
So if I could ask the court to have a look at page 168 of the core bundle and pick up the track changes version of Mr. Monk's statement. The first thing the judge excluded is at the bottom, paragraph 18. The judge excluded the statement that the efficient and reliable operation of London's bus network is therefore critical to the capital's transport system. And then there are some figures which are cited. Now, we say that all that's happening here is Mr. Monk, who is an expert transport planner, is telling the court that the efficient and reliable operation of London's bus network is critical to the transport system. Now, it might be thought that perhaps judicial notice could be taken of that, but the judge's conclusion is that Mr. Monk can't properly tell the court something which is obvious to his job, which is the importance of buses to the public transport network. So it does seem that the judge proceeded on what was in fact an incorrect basis, that the efficient and reliable operation of the bus network was not critical to the capital's transport system.
Well, isn't it more appropriate to submit that there was no evidence as to whether it was or wasn't?
Yes. I won't put it too high.
But what is the basis, as you understand it, for the judge excluding that evidence?
It's that particular phrase or statement was not part of the contemporaneous decision-making materials.
So paragraph 15 of an admissibility judgment, my lord, at page 160 in the core bundle.
Thank you.
Yes.
Well, again, it doesn't seem to me we need to spend a great deal of time on this, Mr. Chaffee. I mean, some of what Mr. Monk says, to which the judge took exception, seems to me to be submissions or argument, which he might have left to you. And some of it says things which anybody who's lived in London as long as I have is well aware of. The proposition, for example, that if black cabs are allowed to use a particular bus lane, they will tend to use it and will tend to prefer that route over a route where they don't have special access. Why shouldn't they? I have observed this for decades myself. It doesn't seem to be a matter of witness evidence. The only points which seem to me are important are where Mr. Monk says, I think at 2 points in his first witness statement and at 1 point in his second statement, we did carefully consider the position of taxis, Your Honor. And Mr. Matthias says that's ex post facto justification. But apart from that, I can't see what all the fuss is about.
Well, yes, I mean, quite a lot of heavy weather has been made of this issue and a kind of line-by-line analysis of the witness statements. But when Mr. Monk says, well, we did seriously consider the position of taxis, all I perhaps need to say is, well, for example, look at the 15th of May press release. It's apparent that the position of taxis was being considered, even at that early stage, because they're referred to and a potential exception for some of them is addressed. Then at the stage of the decision-making process, again, the position of taxis was being considered in considerable detail. We had the LTDA letter, and we had the specific modelling of the consequences on taxis. And that specific modelling, the presentation which accompanied it, expressly referred to the role of taxis in permitting accessibility. So when Mr. Monk said that, we say that the correctness of that is plainly supported by the contemporaneous documents. And that's, of course, one of the reasons why I did the slightly painful process of taking the court to all the contemporaneous material, to show that these issues were properly considered at the time, and it's not just some dastardly lawyers coming up with an analysis after the event in order to justify a decision. My lords, I think that's our summary answer to the judge's approach to admissibility. Unless I can assist the court any further, those are my submissions. Can I just turn my back for a moment?
Yes, indeed.
I'm grateful, my lord.
Thank you, Mr. Chaffee. Miss Rooney? Mr. Matthias.
Thank you, my lord. If I begin with a general point about the approach that my learned friend has taken on behalf of his clients, he's effectively sought to re-argue the case. And that is contrary to principle in terms of an appeal. an appeal is not a rerun of the trial at first instance. It's a review of the decision at first instance, an appeal by way of review, and my lords will be concerned to ascertain whether the judge below, who heard all the evidence and came to a very careful, lengthy and detailed judgment on all that evidence, whether she went wrong in law or whether in her findings of fact and in the inferences that she drew from those findings of fact, she was irrational. And it's as high as that, my lord.
Is it?
Lord, yes. Can I take, my lords, to the decision of this court in Stapleton. It's at tab 16 in our bundle, my lord. This was a decision of this court with Lord Justice Lewison and my lord, the Lord President, and Lady Justice Rose.
Senior President.
Haven't been elevated
Senior President.
to the Scottish judiciary.
My lord, the Senior President. The judgment was that of Lord Justice Lewison, but my lord, the Senior President, and Lady Justice Rose agreed. And if one goes to page 273 in the bundle numbering, paragraph 29, appeals on fact. If I might repeat something I've said before, and that's a reference to Farge UK Limited, appellate courts have been repeatedly warned by recent cases at the highest level not to interfere with findings of fact by trial judges unless compelled to do so. This applies not only to findings of primary fact, but also to the evaluation of those facts and to inferences to be drawn from them.
But this very familiar line of cases, and Grady and McGrady and Henderson and Foxworth and all that, surely talking about trials where judges have heard witnesses give oral evidence.
Well, my lord, in my submission, that's too narrow, because otherwise one is in a position with a hearing by way of judicial review. Turning the page, interestingly, the second proposition, the trial is not a dress rehearsal, it's the first and last night of the show.
Yes, of course.
But my learned friend's approach to this case is rather as though the hearing we had before Mrs. Justice Lang was a dress rehearsal, and he's seeking to rerun all the arguments here today.
Why shouldn't he? I just end up that this is absolutely grade 1 elementary stuff, isn't it? There are notes on this in the notes to CPR 5221 and reference to the DuPont case and so on, but this is the sort of thing one's grown up with. A trial judge who's heard witnesses give oral evidence, particularly in a long and complex trial as this unpronounceable one you're referring to, obviously, has an advantage which is denied to an appeal court. But an appeal court reading these witness statements and documents, we're in just as good a position as Mrs. Justice Lang was.
Well, my lord, moving on, if I may, from that.
Before you do, look at paragraphs 37 and 8 in the decision you've referred us to. What seems to have been the deciding factor for the trial judge was Mr. Yakub's demeanour in the witness box. And that was of critical importance. We're not dealing with that.
No.
This is a public law challenge, which succeeded below in part on a ground alleging irrationality. This court traditionally will look at the evidence underlying that allegation if the matter comes to it on appeal. It's not exercising an excessive appellate function in doing so. That is by contrast with a case where there has been a trial on issues of fact in the court below, and matters arising from that are in contention. That's the Stapleton scenario.
Yes.
Which concerned the the sale of a Gauguin painting. We're not dealing with such an appeal.
My lord, but the findings of fact, so the findings of fact and the inferences on those facts below were the considered findings of the learned judge hearing the case at first instance, and there's weight to be given to them.
She found irrationality, and we're entitled on appeal to investigate whether that finding was well-founded.
Oh, my lord, yeah.
Yes.
Yes.
And as Mr. Jaffe said, I think twice in the course of opening, apologising for taking us to so much material, that he felt compelled to do it because there was that finding in the court below on the allegation of irrationality.
And Lord, yes.
That's why he did it. And we didn't stop him doing it.
No. Mr. Jaffe began his submissions with the finding of irrationality. The difficulty with starting one's consideration of that finding with the irrationality finding is that if one considers the judgment,
to help you, Mr. Mathias, you're not constrained by Mr. Jaffe's order to respond in the same sequence.
No.
You can start somewhere else if you want.
Well, my lord, and it's important to do so because the irrationality finding of the learned judge below began because of her findings in respect of the material considerations point, the public sector equality point, and the legitimate expectation point. It's in the light of her findings on those three matters against the defendants that she considered the question of rationality, and one sees that clearly in her judgment. If one goes to ground 5, if one looks at paragraphs 263, 264, and 265, one sees that it's against the background of those findings that she began her consideration of the question of whether the decisions were irrational. So if I can take the...
Well, would you like to start with ground 1 then?
Yes, if I may, my lord, please.
Yes.
The principles applicable in ground... firstly, at paragraph 100 of her judgment,
Yes.
It's important to identify the material, the relevant considerations that were in play, identified by the learned judge at paragraph 100A and 100B. Namely, the distinct status of taxis as a form of public transport reflected both in law and policy, and the role played by taxis in facilitating accessible public transport for those with mobility impairments. And I might have misunderstood my learned friend, but in the course of his submissions, he was focusing on the bus lane policy in this regard. The material considerations in play here, as you'll see from the learned judge's judgment, went well beyond that. Although the bus lane policy is the important policy to which the learned judge refers, and the role played by taxis in facilitating accessible public transport for those with disabilities is one of the key reasons for the bus lane policy. The assertion, the contention made by my learned friend essentially is that it's simply not correct that the defendants have failed to apply their own policy. in terms of the plan and the guidance, though, there's a clear contraindication that they did. If my lords go to tab 17 in the supplemental appeal bundle. Sorry, I do apologise. Core appeal bundle.
Yes.
This is what we are to understand as the plan.
Yes.
Interestingly, a lot of friends referring to today as a press release. If one looks at paragraph 5 in the learned judge's judgment, one sees her summary of the exchange that occurred at first instance about this. My learned friend told it clearly on instructions that this was the plan. But if one goes then to tab 17 in the core appeal bundle to page 3, we got the version right there.
Starts at 391.
391, and in our bundle it's 397. It's 394 in the print, the version that was handed up this morning, my lord.
Mm-hmm.
So this is the supplemental statement with regard to the plan on the 15th of May 2020. Halfway down the page, we see that the statement, some streets will be converted to walking and cycling only, with others restricted to all traffic apart from buses, as part of the Mayor's latest bold street space measures. Streets between London Bridge and Shoreditch, Euston and Waterloo, Old Street and Holborn may be limited to buses, pedestrians and cyclists to help boost safe and sustainable travel. And then in the next paragraph, second sentence, TfL is looking into providing zero-emission capable taxis with access to both these bridges and other areas where traffic is restricted. Now, my lords, that's a clear contraindication to the assertion that Transport for London were observing the bus lanes policy in making the plan and the guidance. They clearly weren't. To the opposite effect, they were proceeding on the basis that they had an unfettered discretion to exclude taxis from streets where buses could go, but they were going to look to provide zero-emission capable taxis with access to both these bridges and other areas where traffic is restricted. My learned friend identifies that as being an indication that taxis were being taken into account. Well, that's the only reference there is to taxis in either the plan or the subsequent guidance. And far from being an indication that the special status of taxis was being taken into account, or their importance to the disabled was being taken into account, it's, as I say, quite to the opposite effect. When one looks at the plan, and that, of course, we've got the plan on the 6th of May, as elaborated on on the 15th of May 2020, not only do we see that apart from that one reference to zero emission capable taxis in the document of the 15th of May, that is the only reference to taxis. There is, as I say, no other reference to taxis or the importance of taxis to the disabled. And precisely the same applies to the guidance. One can read the guidance from cover to cover and we find no mention of taxis at all. No mention of their importance or their significant status in law and in policy. No mention of their importance to the disabled and those incapable of travelling without the assistance of taxis. Now, in her very detailed judgment, the learned judge looked at the legal principles of material considerations, and we see at page 103, Tesco stores. That's a case my lords will be very familiar with. And paragraph 104, the reference to the dictum of Lord Scarman in Re Finlay, adopting the dictum of Mr. Justice Cook in the Credence case. And if my lords consider the passage at the top of page 97 in the core appeal bundle.
Yes.
And the final lines, there will be some matter so obviously material to a decision on a particular project that anything short of direct consideration of them by ministers would not be in accordance with the intention of the Act. And she then refers at 106 to the judgment of in Kambadzi, a decision maker's own policy will generally amount to a relevant consideration if and insofar as it is engaged. The policy should generally be followed and a departure from a policy ought to be justified. Now, of course, the bus lane policy is a TfL policy. And it is obviously a matter of direct importance when one is talking about a plan to restrict the movement of traffic on roads. Because the very point about the bus lane policy is it affords taxis an exemption from the general rules that exclude traffic, motorised traffic, from bus lanes. So if one is promulgating a plan and a guidance, the very purpose of which is to encourage local authorities and decision makers to exclude motorised traffic from roads, to use the words in the guidance to suppress motorised traffic, to promulgate such a plan and guidance without making reference to the important exception that the bus lane policy affords taxis, is in our submission a grave omission.
But in what respect did the plan and guidance, let's bracket them together, depart from the 2007 policy on bus lanes?
By not identifying taxis, if one looks, for example, on page 406, my lord, that's the in the core bundle.
Yes.
This is the interim guidance to boroughs. Halfway down the page, we therefore need to urgently reconsider use of street space to provide safe and appealing spaces to walk and cyclists and alternative to car use in the context of reduced capacity on public transport and suppressing motorised traffic while allowing essential journeys to take place. Mm-hmm. So there's the suppression of motorised traffic that is the aim of the guidance, or what the guidance that the plan is recommending, has to be, taxis have to be distinguished from the general run of motorised traffic.
No, sorry, that's an answer to a different question. What I was asking, what is there in the plan and guidance which tells boroughs and others to whom the guidance is issued to depart from the bus lane policy conveniently set out at paragraph 118 or 11 or 122 of the judge's judgment?
There's the point that I drew my Lord's attention to in the plan, the 15th of March iteration of the plan, identifying the
well, there's what was to happen at Waterloo and London bridges, but
it's not just bridges, my Lord. It's all the importance of it is. I can't be. The TfL is looking into providing zero-emission capable taxis with access to both these bridges and other areas where traffic is restricted.
yes.
Now, they wouldn't be doing that if the bus lane policy were in operation. They're only saying that we're going to look at giving access to zero-emission capable taxis because they're proceeding on the basis that all taxis are going to be excluded from roads where traffic is restricted.
But there are some areas of London which have been entirely pedestrian.
Yeah.
Is there any? We've been sharing so many documents today, I'm losing track. But does the plan and guidance say anything specific about the use of bus lanes?
No, it doesn't.
I thought you were focusing on the failure to take into account relevant policies.
Yes.
The fact that the document, we have to assess how full it was, what its nature was, makes reference to some taxis being allowed into particular routes which will be restricted to traffic.
Yes.
Why does that mean that they didn't think about the bus lane policy? Point one. Point two, my Lord's question was, in what way does it conflict with the bus lane policy? Now, those are discrete issues. So maybe you could deal with the first and then the second.
The first.
Why is the mention of allowing particular taxis to travel on specific routes that may be restricted to other traffic? Why does that mean they didn't think about the bus lane policy?
Well, my Lord, because the restriction that's being spoken about there is the restriction on motorised traffic.
Yes.
So if the bus lane policy was in operation...
No. The bus lane policy is clearly not in full operation, if by that you mean that taxis have automatic right to go in on the roads concerned. But that's the second question. The first question is why does it mean they didn't think about it? If they are proposing to allow certain taxis into specific routes, then if the bus lane policy meant taxis should be allowed in all bus lanes, if it did mean that, then that might be a change of the application of the policy. But it still wouldn't mean, would it, that they didn't know what their policy was?
No, but there is no indication that they did, my Lord.
But that comes close to a proposition that in every publication where policy is publicised, you've got to recite every single piece of policy every time that you do in fact have in mind, like a list, a schedule. Here are all the policies we know that might possibly bear in this question. Just so as you don't mistake the fact that we know that they're there, we're listing them. Is that an obligation?
If you're promulgating a policy and guidance on a policy that is direct, when I apprehend, my Lord, has got to look at the purpose of the policy and the guidance. Now, the purpose of this policy and this guidance was to suppress motorised traffic. And those are the very words it used. Suppressing motorised traffic. Now, if you're going to suppress motorised traffic and you don't want it to apply to taxis as a whole and as a general proposition, i.e. you want the bus lane policy to continue in operation, then in my submission you have to say so.
In every document?
No, in this document, my lord. This is a document that sought to spread a doctrine of suppressing motorised traffic. So for this document, if the suppression of motorised traffic was not to include taxis, that had to be, because they're motorised traffic. Buses are distinguished, but all other motorised traffic is lumped together.
Mr. Mathias, when you look, if you would please, at page 406, which is the page you took us to just now in the,
yes,
in the guidance, a number of propositions appear which we needn't recite because we've been taken through them.
Yes.
But one of the themes identified there is properly characterised, isn't it, as delay to the movement of buses.
Yes.
Because the capacity of buses has been reduced during the pandemic.
Yes.
And thus there are references to delayed journey times. See the third bullet point within the third main bullet point at the top of the page. Then your reference to suppressing motorised traffic while allowing essential journeys to take place to keep people moving safely. Now, that's the thrust of the guidance in the passage we're looking at. When you come back now to the bus lane policy cited by the judge at paragraph 118, page 100 of the bundle.
Yes.
In a quotation from Mr. Justice Burton's judgment in Eventech, you see at paragraph 13, public carriage, the TfL Public Carriage Office Taxi and Bus Lanes Policy 2007 records that the policy is to allow for taxis in all bus lanes unless their inclusion would cause significant delay to buses.
Yeah.
And is not the guidance in the context of the COVID pandemic identifying a concern about the significant delay to buses in those circumstances? In substance, is that not what it's doing?
It could be, my lord, in particular cases.
Well, in the passages we've looked at just now, is that not what it's clearly doing?
The difficulty is, my lord, that by taxis are entitled under the policy to special consideration, and they're not being accorded any special consideration.
Mr. Mathias, we've just identified the special consideration in the passage quoted from the policy. We've just looked at it. That's why I'm asking you the question I am.
But it won't always be the case. It won't always be the case that significant delay to buses is occasioned.
Well, you're contending for a conflict with the bus lanes policy.
My submission is that the bus lanes policy and the special status of buses and the need that the bus lane policy, the special status of taxis and the disabled people's need for taxis is a special consideration. And the effect of the guidance is to ignore that. And anybody reading this would regard taxis as being part of the motorised traffic that is to be suppressed.
Well, where do you say this conflict lies in the guidance?
In the failure to identify.
Which passage of the guidance is the conflict with the, or failure to comply with, the bus lanes policy exactly?
It's not taken account of. It's not there. It isn't there. They have not identified the special status of taxis. So that anybody reading this guidance would not understand that taxis were to be accorded any different status from other motorised traffic and were to be suppressed.
I wonder if you're not attaching too much importance to your phrase suppressing motorised traffic. It is rather dramatic as a bit taken on its own. It rather suggests that if those three words stood alone, as though nobody was ever to be allowed to take a bus, use a car, or use a taxi, or use anything else. They just have to walk or cycle or stay at home. But if you take that half a page as a whole, there's repeated reference to travel by car is likely to become more attractive. A car-based recovery has significant risks. We therefore need to, dreadful split infinitive, we need to urgently reconsider use of street space to provide safe and appealing spaces to walk and cycle as an alternative to car use in the context of reduced capacity on the public transport network. Suppressing motorised traffic while allowing essential journeys to take place is key to ensuring we manage our road and public transport network. I think you're entitled to say there is no express mention of taxis in that half page, but that half page is hardly saying we need to keep taxis off the road. Seems to me to be saying we need to stop people taking to their cars when they used to use public transport.
Well, that was, yes, undoubtedly, my lord, that was the major concern. But where TfL and the Mayor fell into error is by failing to identify the fact that taxis were in a different category and in terms of law and policy have always been accorded a different status. And that ought to have been reflected in this guidance. That they ought to have taken... There's another, on page 423, my lords, specifically dealing with bus routes. Bus routes have a key function in enabling local access and must be protected as part of temporary LTN proposals, with a general presumption that bus routes and stop locations remain without. Consideration should be given to bus gates to protect bus gates whilst removing general traffic.
Yes.
Now, there's no reference there to... that is another example of where, if they had taken the bus lane policy into account, it ought to have been mentioned. Because otherwise, one is left with the impression that taxis are part of the general traffic that's to be removed.
But as you rightly point out, they're not part of the general traffic, as evidenced by the fact that a very high percentage of bus lane mileage is available to taxis.
Yes.
The Even Tech case said that's perfectly lawful to exclude private hire vehicles, but to give the privilege to taxis.
Yes.
And the bus lane policy of 2007 says that the policy is generally to allow taxis into bus lanes, but with the two specified exceptions, excessive delay to buses or public safety. I can't see what in the guidance says we are going to scrap that 2007 policy.
No, it doesn't say that. This is the material considerations point, my lord. The bus lanes policy was a material consideration that was not taken into account by TfL in the plan or the guidance. It was ignored. And bear in mind, my lords, that this plan and guidance is not simply for TfL roads. This is a pan-London plan and guidance, and the bus lane policy is taking the bus lane policy alone. That is particular to TfL roads. That's a TfL policy. Well, now the effect of this guidance was to tell boroughs and TfL, but to tell boroughs to suppress motorised traffic, to remove general traffic from areas where buses travel, without any reference to the special status of black cabs in law and in law, and without any reference to the importance of taxis to those with disabilities. Because it wasn't, it's plain, my lords. One cannot, in my respectful submission, fairly read the plan and the guidance and come away with the impression that the bus lane policy or the status of taxis or their importance to the disabled was in the minds of those who drafted the plan or the guidance. It's just not there. And one might say, well, how do I know they weren't thinking about it? Well, there was certainly not a hint of them having considered it. And that's what the learned judge found. The learned judge found, and in my submission quite correctly, that it ought to have been something that was taken into account and considered in the drafting of the plan and the guidance because of the effect that the plan and the guidance would have upon taxis and the disabled who depend upon them. And the failure to do so is a breach of that obligation to take a material consideration into account.
Right, thank you.
So even when we get to on page 430, when they do, and I'll come back to this on the public sector equalities point, but even when on page 430 and 431, they are talking about people with disabilities, the most vulnerable, the very people who depend upon taxis in large part. There's still no mention of taxis or the importance of taxis to such people. And my lords, it's not just looking at the plan and the guidance. One has also got to look at the documentation that preceded the plan and the guidance and led to the plan and the guidance being formulated. It's at the supplemental appeal bundle at tab 34, my lords.
Yes.
So this is the only record we have of the discussions, the considerations that were in play prior to the formulation of the plan and the guidance. And there is, in the whole of this document, not a single mention of taxis or their importance to the disabled. We see on page 355, within central London, it's assumed that most TLNR routes would be transformed to provide more space for cycling, walking and or bus services. Among these cycling, walking routes, all space for people movement would be maximised, enhanced bus priority. Page 361, towards the foot of that page. Other measures could include closing of streets, bus and cycle only, or one-way streets. Throughout this entire document, my lords, there is no mention of taxis or their importance to the disabled.
Is there any mention of bus lanes in this document?
There is, well, there's the reference I just took you to, my lord, 355 enhanced bus priority, which would encompass, one would understand that to encompass bus lanes and bus gates. But a bus gate is really a super bus lane.
Yes. Yeah.
So enhanced bus.
It's dealt with at page 361.
Yes, we went to that. That's right. So the passage I referred to, my lord, other measures could include closing of streets, bus and cycle only, or one-way streets. And it's whilst on this document, my lord, it's perhaps just worth, in the context of this document, this is part of the reason why the learned judge concluded that what was really going on was an ambition to extend these restrictions beyond the lockdown. And we see that from certain passages in this document. It's perhaps just worth, in passing, as it were, mentioning them. So on page 347, managing the exit from lockdown in London, foot of the page, there is a unique opportunity now to reshape the road network, to prioritise safe and active modes and avoid a car-based recovery to protect public health and air quality.
Yeah.
And 349, opportunities. Current low levels of motor traffic allow for reallocation of space, right-hand side of the page. Current low levels of motor traffic allow for reallocation of space. And then at the fourth bullet point, pressure to act now to ensure a sustainable future and not return to the previous business as usual. And 350, in the short term, short-term restart, this is the left-hand column, limiting space for motorised traffic, which by implication must be taken to include taxis, and reallocating space for significantly more trips by active modes. And the right-hand column, medium-term recovery, embedding new habits will help to create a healthy, sustainable and attractive city, providing business and quality of life benefits.
But you didn't, and you aren't suggesting there's some bad faith about this.
We didn't say bad faith, my lord. We didn't use the word bad faith, but we did say that there was an ambition that these changes should be permanent, and that comes through very clearly from the documents. It's difficult. I'll take my lords to the relevant passages. It's very difficult to read a lot of these documents in any other way than that there are those persons drafting these documents behind these schemes have an ambition that it should become permanent.
And what exactly is wrong with that?
No, there's nothing. There's nothing wrong. There's nothing wrong
in law.
In law, no. But this was why the learned judge took the view that the pandemic had been used, as it were, I suppose one might say, as a Trojan horse to get these things started. But the ambition was that they should be permanent. And her concern, as it's going back to the rationality part of it, Judge, her concern was by doing it by way of a temporary measure. Now, you can justify a temporary measure by reference to the pandemic, but the point about a temporary traffic order is you don't need any consultation. You can do it fast without it
has to be temporary.
It has to be temporary, yes, it has to be temporary. But then you put in place, you widen the pavements, you put in place the solid bus gates, so there's considerable expenditure in these temporary measures,
Yeah.
and it is not insignificant when one is judging the rationality, although I'm not looking at, rationality at the moment, but it's not insignificant that there is the true motive is to bring about a permanent change in the way streets in London are used.
This didn't set out as a judicial review of the mayor's stated ambition to create the largest car-free zone in Europe or whatever it was.
No.
But however it started out, it's ended up with findings by the judge at 266 and 267, which, as I suggested to Mr. Jaffe, seemed to me to be findings of bad faith from top to bottom of the organisation. And it was never, Mr. Monk wasn't called, and it was never put to him that he's a lying tail rag. But that seems to me what 266 and 267 amount to saying.
Well, I would invite my lord just to consider the documents and the passages in the documents that the learned judge considered. And when we commenced this claim, of course, we didn't have any of these documents. These were TfL documents. It's only when these documents come to light and one reads these documents that it dawns on one that this isn't just an emergency reaction to the pandemic, that this is actually, there's actually an ambition behind these changes that they become permanent. Now, the learned judge came to that conclusion, and in my respectful submission, she was quite right to do so, and that coloured her view of the rationality of the decision to make the temporary order, as and my lord has seen how she puts it in her judgment. Because perhaps the clearest example of what I'm now talking about is at page 352. That's the section headed "Leading the Change for a New World."
Yeah, 352
of the supplemental appeal bundle. Sorry. 350. Yes, it's a tab. It's a document I was on, my lord. Tab 34. It's the third bullet point, which I'm sorry, the way this is printed out, those photographs have obscured the rest of the text, but I can tell my lords what it means. What it says is...
To be bold in shaping a new... something.
It says it's a new normal defined by more active travel, cleaner air, healthier streets and citizens, and action on climate change. Mm-hmm. I don't know whether my learned junior is very good at doing this sort of thing, whether he can manage to print this out so that it's not obscured, or maybe somebody from TfL can. But I want to see how one can read that and not come away with the conclusion that there are those at TfL whose ambition is that these changes should be permanent.
But that isn't what the claim seeks judicial review of. And let's put the Bishopsgate claim to one side for the moment. The claim is for judicial review of the plan, which is one or possibly two press statements, and the guidance, the interim guidance. So you're entitled to point to a document of this kind as illuminating the thinking of TfL in publishing the guidance, but it is the guidance that you are seeking to quash.
This is
quashing a sort of long-term ambition.
No.
It's a rather difficult concept.
I took the court to this document because it's the only document we have got. It's the only document that's been disclosed that gives any indication of the thinking behind the plan and the guidance. So, as I say, I took my lords to it in the context of my submissions on material consideration.
Yes.
But I only thought because we were on it, it would be worth showing my lords the passages in it that were part of the information that informed the judge's conclusions that are found in that part of the judgment dealing with rationality. She wasn't flying a kite of her own when she spoke about the long-term ambitions. And she wasn't saying bad faith, and we certainly weren't saying bad faith, and these are long-term ambitions, as my Lord Justice Beale has pointed out. That wasn't the basis of our challenge by way of judicial review, but it's.
When you say it informed her conclusions on irrationality, does that mean that it influenced that conclusion in her judgment?
It's part of it. It's part. She essentially, her finding on irrationality is based is in this way. She found that there were failure to take account of material considerations, a failure to fulfil the public sector equality duty, a failure to take account of legitimate expectations, and this is quite clear from her judgment, the temporary measures were, I've used the word informed, by a long-term ambition, so that they were not, that they were far and away in excess of what was in fact required to deal with the short-term exigencies of the pandemic.
Well, they might be a rational long-term ambition to which your clients take exception. They might. That doesn't make them irrational.
Not on their own. No. I don't suggest it does, my lord.
So if they informed the judge's conclusions on irrationality, was she herself taking into account something that she ought not to have done in reaching that conclusion as a matter of law?
It's paragraph 266 of her judgment.
I'll find the answer to my question there, will I?
Well, I can't better the way she puts it, my lord. I wouldn't try to. Right. She'd identified the flaws that I've outlined in terms of our grounds 1, 2, and 4. And she goes on in 266 to say, in my judgment, the flaws identified were symptomatic of an ill-considered response which sought to take advantage of the pandemic to push through an emergency basis without led consultation, radical changes, plans to transform parts of central London into one of the largest car-free zones in any capital city in the world, and to rapidly repurpose London streets to serve an unprecedented demand for walking and cycling in a major new strategic shift. And those were all statements made by the mayor.
Well, again, it verges. I'm so sorry.
That wasn't the claim you were making.
No, it wasn't. But we were asserting irrationality.
And that again verges quite close, doesn't it, to bad faith? That formulation. Push through on an emergency basis without consultation.
Well, a temporary order does not require consultation. And
that's the point, isn't it? The implication, well, it's hovering over the implication that this is being done by way of a temporary order, precisely because it doesn't involve consultation and reach a situation that then can be more easily made firm. I thought that's what you were saying just now.
Oh, all right. Well, what I'm saying is one cannot read the documents. There are more documents than the one I just referred to. One cannot read the documents without coming to the conclusion, as the learned judge did, that this whole scheme was not devised solely because of the pandemic or to resolve the problems occasioned by the pandemic. We said that in our skeleton argument.
Don't you see that that is very close to alleging bad faith?
Well, it's not bad faith if there is if the temporary order can be justified. If the temporary order can be justified, there may then be an ulterior ambition. If the temporary order can't be justified, then perhaps.
So how can it be an additional factor for the judge? logically,
Mm.
in the light of what you've just said?
She thought that the decision itself was a bad decision for the reasons she found on grounds 1, 2, and 4. And
I
then she
understand that, but that's much more confined. In 1, 2, and 4 are all saying in different ways that the plan and guidance failed to take account of the special position of taxes, the existing policy regarding taxes, legitimate expectation, and the PSED, all relating to taxes and their users, particularly disabled users. I understand that. And 1, 2, and 4, in a way, go together. Not there's some overlap.
Yeah.
But this is going much wider.
Yeah.
And if she had upheld any or all of 1, 2, and 4, but not 5, I would have expected the quashing order to be that the guidance, query the plan if it has a separate existence, but the plan or the guidance are quashed insofar as, or to the extent that, they fail to take account of the special position of taxes. But ground 5, and particularly her findings at 266 and 267, are saying the whole thing is unlawful from start to finish and needs to be torn in pieces and start again. Not confined to taxes. The whole thing. That's an astonishing proposition on written evidence with no cross-examination of the decision makers. And when it wasn't even the pleaded claim.
Well, my lord, in terms of the relief that she granted, in my respectful submission, the plan and the guidance and the order should all go if I get home on grounds 1, 2, and 4. With respect, my lord, the decision to quash the plan and the guidance and it wouldn't be possible to, as it were, quash them in part, because they are fundamentally flawed and were arrived at without due regard to the public sector equality duty, apart from anything else. So I'm not satisfied that the learned judge's finding on irrationality was the only basis upon which she could quash the plan and the guidance and the order. But in terms of her findings, her findings on irrationality would stand in my submission, even without what she says at paragraphs 266 and 267. In my submission, her irrationality findings don't hinge on those paragraphs. She goes a lot. Not only does she identify if a plan is made without taking account of material considerations and without a public sector equality duty, having due regard to the public sector equality duty, and without and in breach of the legitimate expectations of an important sector of the London community, that's likely to be regarded as an irrational decision. It's wrong in in 3 rather major ways, and it would be difficult for a learned judge to say that no reasonable authority would have come to a decision that was based on 3 such serious breaches.
All right. Well, now you started with ground 1. Is this it's 4:20? Is this a convenient point to break off, or
Well, it is convenient, my lord, if it's convenient to you.
When are you going to move on to a new topic? I don't want to stop you if you've got a few minutes to go on a particular topic.
No, and unless I can be of further assistance on ground one, because ground one only applies to the plan and the guidance.
Yes. All right. So
by virtue of the letter that the LTDA sent, perhaps ought to just very briefly draw the court's attention to the timescale that we're talking about here.
We've got the chronology at tab 5.
Yes. It's a document. It's put out of order in the bundle. It's a document at it's at tab 46 in the bundle. This is with reference to the order. Tab 46.
46.
That's an email.
Yes, and if one, my lord, goes to page 470. Now, with a temporary order, this is a meeting that was held with the taxi trade on July the 2nd.
Yes.
Prior to this, there had been no consultation of any kind with the taxi trade order.
This is on Bishopsgate.
Yes.
Yes.
This is material considerations on you found that the material considerations had been taken into consideration on the A10 order. But my lord, it's important to focus on this, that the taxi trade meeting took place on the 2nd of July 2020. The A10 order, pursuant to the regulations, has to be advertised for 7 days prior to being made. And it was in fact advertised in the Islington Tribune on the 3rd of July. So this meeting with the taxi trade was convened the day before the order was advertised.
Mm-hmm.
And the order was made subsequently on the 16th of July.
Yes.
In the course of this meeting, and subsequent to this meeting, that the letter from Mr. McNamara, to which you've been referred, this is at tab 50, was sent. That's on the 8th of July.
Yes.
And my lord, it's only in light of that letter and the information contained in that letter that the learned judge concluded that the special status of taxis and their importance to the disabled had been taken into account by the decision makers.
Of the order.
Of the order.
Yes.
So they got by, as it were, by the skin of their teeth, so far as the order was concerned, not because of anything that they had done, but prior to advertising the order, but by virtue of the fact that they saw fit to speak to the trade about it on the 2nd of July, and then received this letter. If one looks at all the previous documentation in relation to the making of the order and the consideration of whether to make the order, there's no reference to taxis or their importance or the significance of taxis to the disabled.
Speaking for myself, and perhaps I should have said this to Mr. Jaffe as well, I find it easier to approach this case by looking at first at the plan and guidance, what I call the macro claim, and then at the A10 order, the micro claim, rather than taking each legal topic for one and then the other and so on. And so I was slightly thrown when we jumped from the plan and guidance to the order. But anyway, having said that, shall we leave it there?
Yes.
And 10:30 tomorrow?
If you please.
Yes. And if Mr. Streeton or somebody could supply us with the missing text of that document you just showed us where the photos go. It doesn't have to be particularly pretty, and if it's just one line of print, then you can read it out to us.
I will, yeah.
All rise.